I'm June Bessick. I'm the Executive Director of the Kernigan Center at Columbia Law School and a lecturer there. And I'm also the chair-elect of the ABA section of Intellectual Property Law. Let me start our roundtable by posing some questions to our panelists. First of all, why is this bill important? Can't copyright owners just go to state or federal court in order to sue and get damages? Let me ask you to start with that, David. If you could just say a few words, introduce yourself.
Sure, yeah, I'd be happy to. Thank you, June. I'm David Trust. I'm the CEO of Professional Photographers of America. We are an association that represents about 30,000 professional photographers of all types here, actually in 64 countries, but almost all here in the United States. There's a couple questions there. First, can it go to state court? No, and that is all of these IP issues have to be brought before a federal court. That's the only way to pursue an infringement here in the United States, is to pursue it through federal court. And for many of our members, quite honestly, June, that's no option at all. The 70% of our members report multiple infringements over the last several years. Almost all of those infringements are reported at $3,000 or less. So the American Bar Association conducted a study. They report that it costs upwards of $400,000 to bring an IP case to fruition in federal court, to try to recover $3,000 or $5,000 or $10,000 or $800 or $1,200. And that's the key, is that our members earn on average $34,000 a year. So an $800 infringement and a $1,200 infringement is big money to a photographer. It's important money. And of course, that $2,000 doesn't hit the radar screen up in Washington, D.C., but it makes a real difference in the lives of these hundreds and hundreds and hundreds of thousands of small creators, who are living on $34,000 a year. It's a mortgage payment or food on the table, or maybe healthcare, or maybe the first family vacation in 5 years, or piano lessons, or Little League. The point is that it is important money that they should have the ability to recover in some way, but they don't, because the only remedy is in federal court, and you're going to federal court to recover the kinds of infringements that happen hundreds of thousands, maybe millions of times a day here in America. We are the #1 infringing society of photographic works. And so it is a big problem that federal court is the only remedy. The Case Act flips that dynamic. The Case Act, if passed, would change all of that for hundreds of thousands of small businesses.
Thank you, David. Let me turn now to Tom and ask, what kinds of cases could be brought before this small claims board?
Hi, June. Thank you. I'm Tom Kennedy, Executive Director of the American Society of Media Photographers, where we represent independent photographers working for publication. And typically, there are going to be infringement cases. And let me give a good example of a perfect case. This was brought to my attention by our former National Board Chair, Jenna Close, who actually testified with David last year in the House hearing on the bill. And she cited the case where she was doing special work for a client regarding alternative energy. She made some pictures that the client intended to use for marketing purposes, both in the digital arena as well as as the backdrop for their trade booth. And she produced those images. The client put them on the website, and the competitor to the client, who was their primary competitor, stole the images and began to use them themselves, and actually use them for their own trade booth. So imagine her chagrin when she walked into the trade fair with her client, very excited to see the work blown up and on large display, only to discover that the client's main competitor was also using the same images.
Thank you. So, Terrica, I have a question for you. What does it mean when people say that the small claims process would be voluntary? How can it be voluntary if somebody sues you?
Sure, thanks, June. My name is Terrica Carrington, and I'm VP Legal Policy with the Copyright Alliance. Just to jump straight into that question, the small claims court that would be created under the Case Act would actually be an alternative to federal court. And so what that means is that not only would respondents who are like plaintiffs in federal court, not only would they have the option to decide whether or not they want to take a particular case to federal court or to small claims court, but also the defendant or the respondent under this Case Act would actually have the ability to decide whether or not they wanted to participate in that proceeding. So it would actually be entirely optional for all parties involved.
Okay, thank you. Now, another part of this legislation is to house the board in the Copyright Office. which is located in Washington, D.C. Does that mean that people are going to have to travel to DC to participate? And wouldn't that be a hardship on both the claimants and respondents? I wanted to ask Mary that.
Thank you, June. This is Mary Rasenberger. I'm Executive Director of the Authors Guild. We represent the interests of book authors and freelance journalists of all kinds, and we provide a great deal of support for authors and freelance journalists. To respond to your question, that is the beauty of the CASE Act, is that you do not have to travel to Washington, D.C. All of the proceedings are conducted by phone, video conference, and email. No one has to spend the money or take the time to travel to DC or to any courthouse. You can engage in the tribunal at home or at your office. The tribunal needs to be low cost, simple and efficient, so that creators can bring these low value cases without a lawyer. And in this way, it keeps damages low to what's needed to compensate the creators, whatever their fee might be, whether it's a couple $1,000s or whatnot. You don't need to have damages that also pay attorney's fees. This is very important for the Authors Guild, to allow authors to be able, and other creators to be able, to bring these cases themselves easily from their locations, wherever they reside or work.
Thanks, Mary. Let me just follow up.
I was going to say, June, if I could just jump in on that with Mary, and that is that there are those who are not in favor of the CASE Act, not surprisingly, and some of the claims that they are making is, and one in particular is, someone who's accused of an infringement in Hawaii is going to have to spend money to come to Washington, D.C. And I think it's worth just mentioning that is one of the great concerns out there by people who are not in favor of it. It's just not true. I mean, it's very elegant in that way, and that it will all be done remotely. And so I think it's worth mentioning the confusion that's out there about that point, and the fact that nobody will have to leave their homes to participate in a small claims process.
Thank you. That's a very helpful clarification. So Mary, how does somebody find out if somebody's bringing a claim against them? I mean, do they get email, a phone call, snail mail?
No, the respondent will receive formal notice. And this is important because there's no way as a respondent that you won't notice that you've been served. You will receive at least 2 formal notices. First, you are served with process just as you would be in federal court. A process server will come, or otherwise you will be given legal documents saying that the plaintiff or claimant has brought a case against you in the small claims tribunal. You will, and those papers, I should say, will instruct you on how to respond and how to opt out should you choose to opt out. There will be clear instructions that if you don't want to be in this tribunal, you can opt out, and it will be a very simple process. Then you will also receive an official letter from the Copyright Office's Small Claims Board. Just in case you didn't understand what the process was, the Copyright Office notice, or I should say the Copyright Small Claims Board notice, will again tell you what the process is, give you simple instructions for opting out. And then if you still don't respond, you will receive another notice from the Small Claims Board letting you know that there will be a default judgment if you don't respond to either respond to the claim or to opt out.
Okay, thank you. So David, I want to turn back to you again and ask you, is there a limit on the amount of damages that a claimant could recover? And if so, do you think it's a fair limit?
I mean, I think it's a fair, yes. The answer to the question is yes, there's a limit, and I think it's a fair limit. The small claims process is limited to $15,000, a cap of $15,000 on per infringement, and a maximum of $30,000 per case. And so it's $15,000 and $30,000. I've never been told, maybe Terrica can jump in here maybe she has something more definitive on this. I've never been told exactly how we came to the 15,000. I believe it comes to 1/10 of what you could file for an infringement in a federal court, as I understand it, and there is no limit to the number in federal court. But we think it's very fair. I mean, and we think it's fair for everybody. The Copyright Office initially drafted its recommendations for this legislation. The $30,000 limit was in that draft a few years ago when the Copyright Office first issued this. I guess it's been 5 now. And so it's that, and it has stuck, by the way, to the $15,000 and $30,000 limits and all of it. We think it's very fair. I mean, there are some creators who are infringed regularly, and it comes out to much more than 30,000. So they would have to decide whether or not to pursue it as a small claim or in federal court. And then there are those that just think it should be $1,500, and which is silliness, because they're not allowed to, should not be allowed to place the value of someone's work or an image, in our case with photographers, set that for them. And so we think that it is a nice middle ground, the $15,000 and $30,000 cap. Terrica, I don't mean to put you on the spot, but as I understand it, it comes out to 1/10 of the federal court system.
Yeah, David, that's absolutely correct. And if I can just add a little bit to what you said, there was a study done by the ABA some few years back that actually found that most copyright attorneys will not take a case that's valued at $30,000 or less. And so basically that created a gap where creators that had claims of worth $30,000 or more could have effective counsel in federal court, but those with claims of less than $30,000, they don't really have an avenue to pursue those claims. And so the case that kind of steps in and fills that gap, allowing for claims of less than $30,000 to be pursued even without needing to hire assistance of an attorney.
Thanks, Terrica. I just want to follow up with you because I have another question. And that's, you know, we've all been talking about how the Small Claims Board and the whole regime would help copyright owners, but is there any benefit for users of copyrighted works to participate?
Yes, there definitely is. Just speaking directly at how expensive federal court is, it's not only expensive for creators or copyright owners who want to pursue various claims, but also for users of copyrighted works who maybe have a claim for fair use or feel as though their use of a work is not infringing and they want to bring a case. It's equally expensive for them to be able to pursue those cases in federal court as well. And so what the Case Act does is not only does it have claims that copyright owners can bring, but also claims that users of copyrighted works could bring. So for instance, there's declarations of non-infringement. So let's say I'm a documentary filmmaker and I have used some music in my film and someone has accused me of having infringed that work. If I have a legitimate reason to believe that what I'm doing is not infringing and I want to get a determination by a court to stand in for that, most likely I'm not going to be able to afford to go to federal court. And so the small claims process under the Case Act would allow me to bring a claim like that. In addition, there are claims under the DMCA for misrepresentation. So if you send or receive a takedown notice or a counter notice and some information is misrepresented on that, this would actually allow copyright users to be able to bring such a claim into a tribunal that they can afford to do. And of course, as David just touched on, the cap on damages, there's limited liability in the small claims process that's significantly lower than in federal court. So if there's any chance at all that, you know, maybe you weren't aware of an infringement that you were committing or some liability that you've opened yourself up to, it definitely makes a lot more sense from a financial perspective to go to the small claims court rather than open yourself up to potentially unlimited liability in federal court.
Thank you. All right, Tom, I'd like to ask you, I know that there have been complaints about legislation because people think it could be used by copyright trolls. What do you think of that? Is there any chance that the bill could be used to file frivolous suit by copyright trolls?
Frankly, I think that's a complete red herring, June, and I'll tell you why. First of all, the system is voluntary. If a person doesn't want to be sued or doesn't agree to participate, they can have the option to opt out. And so that alone, I think, would prevent trolling. But in addition, there are significant penalties in the bill as it's currently constituted that would affect bad actors. So they could be banned from using the system for a period of time. And if they continue to persist in that, they will be subject to fairly significant financial penalties. And finally, for me, it doesn't make sense to me that trolling, the way that the argument is being framed by opponents of the bill, because why would you invest money in trying to bring claims through the process if you knew that you were going to have them tossed out because they're clearly frivolous? It just doesn't make sense to me at all.
Thanks. Mary, did you have anything to add there?
Yes, thank you. So, yes, everything that Tom said is exactly correct. I would just add that the economics don't work and the incentives don't work for lawyers to bring cases in the small claims tribunal. Copyright trolls, as they're referred to today, they are lawyers, and they are lawyers who bring a large volume of copyright claims on behalf of creators, because right now it's due to the problem in the system that right now that is the only way that's economical to bring these claims at all. They have to be brought in large volume. And when you do large volume litigation, you don't always check all the I's and dot all the T's. There's no incentive for these lawyers to be in the small claims court. It just is not enough money in the damages that plaintiffs can collect, and there's no incentive, honestly, for the claimants to hire lawyers, because the lawyers would take anywhere between 25 to 50% of the award, and the awards are small, so you wouldn't want to do that, and you don't need a lawyer. So actually, the small claims tribunal is a solution to trolling.
Thank you. Before we talk about the status of the bill as it currently stands, I just wanted to ask if any of you had anything you wanted to add or wanted to talk about anything I hadn't brought up. All right, then I'm going to ask you, Mary, to tell us, where does the bill currently stand? What can folks who are listening to this discussion do to ensure passage of the CASE Act?
Thanks, June. That's a really good question. The CASE Act passed the House of Representatives last fall with overwhelming support, with 410 members voting in support and only 6 against. The bill is in the Senate now, and we are hoping it will move forward soon once things quiet down on the Hill and we return to somewhat of a new normal. And that's where you come in. Now is the time for you to reach out to your senator and tell him or her to support the CASE Act and to support creators. You can use the ABA tools that are on their website to write or call your senator. And believe it or not, it makes a huge difference when members of Congress hear from their constituents. You know, we hear our own members at the Authors Guild will say, well, you know, what difference is it going to make if I send a letter or call? Believe it or not, it really does make a difference. And we see that when we are waiting to hear from a member of Congress about whether or not they will support an action that we are advocating for. We might hear back later that day, we heard from a bunch of authors or creators in our district, and they the senator, in some cases the congressmen or women, has decided that they want to support. So I cannot emphasize that enough. Your voice matters. Members of Congress want to hear from their constituents. And I would just add that the ABA does have form letters that you can use, but you can also personalize these messages, and sometimes that has even more of an impact. And we thank you for all of the support that you can give us in getting the CASE Act passed.
Yeah, if I can, thank you. If I can jump on that, I agree with everything Mary just said, and I think we're at a critical moment here. I mean, all of the organizations on the screen here, and a lot of others, have been working in concert, I think, with each other for a lot of years to try to get the CASE Act brought to where it is right now. Creators, these small creators, the smallest of American businesses, they don't ever get this seat at the table, so to speak. And this is their opportunity to be front and center. We have been concerned at some of the slowdown. We feel like it has been somewhat intentional at times by opponents of the bill, and we are working hard to sort of get that on the logjam cleared. As Mary pointed out, this passed 410 to 6 in the House. And as far as we know, there are 99 senators in favor of it, as far as we know, and just one who has put a hold on it, and no one has joined him in that hold. And now there was initially another one who was Senator Paul, and he withdrew his hold on the bill. And so there's just one person right now. So to get this thing moving, we feel like it's just a matter of getting Senate co-sponsors, more Senate co-sponsors on the bill, which is exactly what Mary has just said. So more than ever, because of the one hold that's there, we just need more and more co-sponsors. And I think that's all of our jobs right now to solve this generations old inequity that's in our system. It was never intended that these small creators would be left out of the copyright system. It's just the way it evolved, and the CASE Act will change that. And we're at a critical point right now. If we don't make it through this Congress, who knows if it would ever have enough energy to continue on in the next Congress. And so things are tricky right now with the COVID-19 pandemic and with an election coming up, and we need co-sponsors quickly because of that.
Well, thank you, David, and thank you to all of you providing such useful information on the CASE Act.
Thank you.
Thank you.
Our pleasure. Thank you.